Hello.
Hello, Mr. Sian, it's Sian calling from the legal Ombudsman.
Oh, hi, Sian. Thanks for calling me back.
No problem. Is it a good time to talk?
Yes,
I know I've phoned you a little bit earlier than I said I would.
no, that's fine. It's just that
Okay.
can you just confirm to me when we last spoke?
Yeah, of course. Well, I'll just need security questions if that's okay with you, Mr. Sian, then we'll discuss the details. Is that okay?
Yeah, that's fine. Yes.
Fantastic, thank you. So just confirm your full name,
Mr. Sajjad Hussain.
your email address,
fatahbegum@gmail.com.
thank you, and the solicitors that the complaint's against.
Burke Niazi Solicitors.
Thank you so much. And just as you're aware, calls are recorded, but they're mainly for feedback and quality purposes, okay? So I'll just have a look back. I believe the last email correspondence we had was on, well, we last spoke on the 13th of January. I think we weren't able to, we didn't have enough time to talk, but it was regarding the fact that there was a couple of complaints we've put to the solicitors that you wanted us to put to the solicitors, and that they've requested some time to respond to them, and that we've suspended the case.
Yes, but did we not make? I was made aware that you wanted me to confirm everything by the 13th, and but you also made me aware that the following week you will be going on holiday.
Yes, correct. Well, last time we spoke, obviously I sent an email, I think it was on the 10th. Let me just check my records. Yeah, sorry, it was on the 9th of January with a copy of the confirmation of your complaint, and that 3 of the complaints that we discussed were what we call premature complaints. So what that means is that I can't see that these 3 complaints, outside of the other 12 that we've confirmed, had previously been complained about to Burke Niazi. So I explained that the process would be that if you wanted to pursue those 3 complaints alongside the others, we would have to put them to the firm and give them an opportunity to respond to the complaints. And was that something that you wanted us to do? Now, I believe you responded back to say, yes, speak to the firm, get their responses. So obviously I've done that, and the firm have said that they will require the necessary time to look into the complaints and respond.
Okay, but the point is that I'm sure we made arrangements. Did we not arrange for for our next conversation to be at the end of January?
Yes, yeah, correct. When I returned that back off annual leave, yeah, we said we would pick back up.
Did we not make an appointment?
Yes, I'm really sorry that I didn't give you a call, at the end of January. I'm very sorry.
Okay, that's fair enough.
I did miss your call yesterday, so
Okay.
I didn't return that.
Okay, all right. So that's fair enough. Obviously, my understanding was that we had arranged an appointment, I think, on your first day back, but that must have been an oversight on your part, and that's fair enough. The other thing is, when we last spoke, when I last spoke to you, I did query that going forward now, what would be the time frame of looking to conclude your investigation, and you had indicated to me that most likely you're looking to have everything wrapped up by March. Do you remember that conversation?
Yes, correct. So when we spoke, I said that I'd give you a brief outline of the process. So at that time, we confirmed your complaints. I would speak to the firm, get their comments. I would send an evidence request out, and then I'd look to try and review that information, as soon as I could. And, I said roughly it may potentially be March, depending on other issues that came about. So
Yeah.
following that conversation, however, I did, like I said, we sent the email across to say that a couple of the complaints we agreed were actually what we call premature complaints. And I know sometimes you obviously we email, but it is easier over the telephone to explain what that process is. But I did email the night to kind of explain the process and say, this is, do you want to pursue these complaints? Because we'll have to allow the firm up to 8 weeks to respond to those.
Okay, all right. So, like I said, my understanding was that would be proceeded, as an indication in our lengthy conversation, I believe, prior to our last conversation, that would be completed by March time. Then subsequently, obviously, you've made me aware that you would have to give them more time and have suspended the case. So I wanted to discuss this issue with you about suspending the case in the interim. But before I do so, I just wanted to focus in on the 12 point, to conclude the terms of the complaint. So if you can just kindly remind me of what the three extra premature complaints were that Burke Niazi are presently considering.
Yes, of course. There were three complaints, so I'll go through each one. So it was the first one was the firm communicated with third parties regarding your case, despite asking them not to. So the fact that they discussed, they discussed with, well, as we discussed, they discussed with other third parties. You requested them not to do that.
Yes.
Another complaint is that the firm, just bear with me. Sorry about the senseless issues, to bear with me.
Yeah, sure.
So the second complaint was that the firm wouldn't share any details of your mother's solicitor with you, or any third-party contacts with you when you requested them. That was the other complaint. And then the third complaint was that the firm didn't make you aware that there was a hearing on January 2022, and what they intended to discuss at that hearing.
Yes, okay, all right. So that's fair enough. That's just quickly jogs my memory. So what I would like to do is, before returning back to this file being suspended, I just wanted to go through the letter that you did send me, dated the 9th of January, and all the points there, because I think some of them just need slightly adjusting. Okay, so the first point, let me just see if I can see what the letter was. Just 1 second, please. Here we go. So I'm just gonna go through them all, and I, obviously agree to those things that I feel that you've captured correctly. So the first point is the firm did not make a legal aid application until May 2021, 6 weeks after Mr. Hussain had instructed the firm. Yes, I agree with that. That needs to be looked into and has been previously raised as a complaint with the firm. The second thing, the firm only gave Mr. Hussain one choice of barristers, which he believes limited the representation of his case. And yes, we've discussed this, and we've said that obviously I was basically coerced into really given only one choice, which was the preferred barrister of the solicitors. The point number 3 is the firm and barristers only met Mr. Hussain a couple of hours before the hearing on the 20th of May, which was inadequate time to prepare for the hearing. Yes, I mean, this is a general complaint that I've not had an opportunity to fully prepare, have been given time with the barrister, and that's obviously been raised previously. And number 4 is Mr. Hussain requested to speak to the firm and his barrister immediately after the hearing on the 20th of May, but they were unable to speak with him until the following week. And that is also correct as well. I mean, I just had a brief conversation before the hearing, and then subsequently, I believe the next time I spoke to the barrister was on the 25th of May, which was obviously the following week. Now, the point number 5 is the point that requires some adjustment. It says here, the firm should have submitted a statement given by Mr. Hussain to the courts on the 14th of January, but did not do this. That requires some amendment, because it was not the 14th. I've gone through my records now and determined that to be 4 p.m. on the 17th of June. So, can you kindly update that? So it's not the 14th, it's the 17th.
Okay, yeah.
So as you can appreciate, there were substantive hearings on the 20th of May. There were the substantive hearings on the 20th of May, where I was legally represented by Burke Niazi solicitors and the barristers. Now, as a consequence of that, the hearing, as you're appreciative, that one of the things that happens at court hearings is a directional hearing of when the next hearing will be and what needs to be prepared for the next hearing. So at this hearing on the 20th of May, what I recollect as being what directional hearings were, that obviously a further statement needed to be submitted by me by the 17th of May. By 4 p.m. and those were in relation to the injunction orders that had been further finalized at the hearing on the 20th of May. So that was what was required of me, and then obviously a further hearing was listed for the 5th of July. So that was so this point here is a point of great contention because at this stage, obviously following the hearing on the 20th of May, I was both legally represented. There was a legal aid fund in place. There were the solicitors had attended the hearing, and they were fully aware of what their obligations were in a professional capacity. Now, what actually had happened is that on the 17th of May, I had pre-booked an appointment with Mr. Berkniazi with the intentions of finalizing my statement regarding this matter. So Mr. Berkniazi would have had an opportunity to finalize this and get it in time. Now, he had failed to attend that pre-booked appointment. It was booked for 2 o'clock. He had failed to attend that appointment until and then eventually I had to email him, and he contacted me at 22:03, knowing full well that I had only availability until 3 o'clock because I had arranged a booking with the other party to speak to my mother on the telephone. So. And it is that conversation that I had on the 17th, reminding Mr. Niazi, reminding Mr. Marcus that there was a statement to be handed in. Now he gave me assurances that not to worry about that. So we've spoken on the 17th. I've reminded him that I need to submit a statement. We've not had an opportunity to speak prior. And I was just very concerned that we've not had an opportunity to discuss what I am going to be writing in this statement. And he's told me, don't worry about that, and we can discuss that. And then obviously that conversation could not proceed. So because obviously the limitation of time. So the following day, the 18th of June, we had a very lengthy conversation. And so the first thing I wanted to query from him was to establish that was I correct? Did we have to submit something by the 17th of June? And he said, well, I don't want to discuss that right now. What I want to make you aware, and this is the first time that he had made me aware of his concerns of my litigation capacity, and so therefore he derailed the purpose of the call with something very substantive, and namely the contentious point of raising the issue of my litigation capacity. Now, but the problem, the issue still remains is that irrespective of whether Berkniazi solicitors, in collaboration with the barristers, at this stage had concerns regarding my litigation capacity or my ability to instruct them, that's irrelevant to a court order that they have been received. And that is the point of a complaint, is that that obviously yourselves will have an opportunity to investigate, irrespective of whether they have concerns or not. There was a deadline date, a court order required a statement to be submitted. And as far as my understanding is that no statement was submitted on this date. Yes. So I just wanted to clarify that particular point to yourself, is that my concerns are that the aspect of communicating with Berkniazi solicitors regarding various other points, now the situation has been derailed through this very serious allegation, effectively an allegation against my own capacity. And the reason that this had been raised by Berkniazi is because I had simply made a very serious allegation against the judiciary. So I just wanted to obviously explain that to you, and obviously that can be evidence that okay, in order to uphold this complaint, there should be evidence on the part of Berkniazi that's saying, look, so the complaint is that if I was required to submit a statement, why was the statement not submitted? Because that's a very serious matter. So I just wanted to amend that aspect and just clarify for your understanding what the complaint is there. Okay.
Yeah, so it was the 17th of June. It was actually due.
Yeah, 17th at 4 p.m. Okay, so I'm just moving on past these. Yeah, I just want to move on to all the other points before. Yep. So the firm did not tell Mr. Hussain that they intended to consult with his barrister privately, and that they intended to apply regarding his litigation capacity. I just wanted to amend this. I'm not sure. I'm not sure that clearly captures what happened. The firm did not tell Mr. Hussain that they intended to consult with his barrister privately and that they intended to apply regarding his litigation capacity. So just to clarify, I think what I was trying to state here is that Mr. Michael Barrett, Mr. Barrett made me aware on the 18th that both him and my barrister Asma Nizami were in consultation with each other regarding our previous conversation that I had on the 25th of May, where I had sought legal advice from the barrister regarding my ability to appeal the final hearing in February, and also, more importantly, asking for legal advice from my legally represented barrister of what are my options where I believe the senior judiciary have had their services privately commissioned out. So that's a conversation that took place between me and the barrister and the solicitor on the 25th of May. Now, subsequently, Mr. Barrett made me aware on the 18th of June that both Mr. Barrett and the barrister have been having private consultations with each other and trying to find ways forward, and raising concerns with each other. And so therefore they've been basically speaking in my absence of raising these like issues among themselves, that and like basically colluding with each other to have it raise what I believe is a false flag safeguarding alert. So yeah, that's what I think I was trying to say in that, is that they've been speaking on in relation to myself to my detriment in my absence. And then also, they made me aware for the first time on the 18th of June, obviously in that conversation, at which time it became evident to me that there was something malevolent taking place. So I then insisted on speaking to Miss Niazi on this matter. Subsequently, the following week, so what had happened was that, just to clarify on the second point, Mr. Barrett had made me aware that under his legal obligation, a professional obligation, he would have to make the courts aware of their concern, as a matter of fact. And I had stated to him that he should not do that. I gave him you should not do that, because this places me in a exceedingly detrimental situation, and at the minimum I should have the opportunity to speak to the barrister regarding what concerns that they've been having in consultation with each other, and so therefore, yes, it was subsequently that I had told them, once following that conversation, which took place, I believe, between myself and Miss Niazi on the 28th of June, that there was a hearing, mind you, that coming up on the 5th of July. So I had an opportunity to speak to Miss Niazi on the 28th of June regarding this allegations of concern that they have regarding my litigation capacity. And I had told them subsequently, Mr. Barrett instructed them that you should not do this. All right, because obviously you're looking to effectively derail the upcoming hearing on the 5th of July. And so therefore, they were basically stating to me that they're not in a position to prepare me for this hearing on the 5th of July because of their overriding now concern regarding my litigation capacity. I had quite clearly articulated to Mr. Barrett that he should, at this stage, I believe he was acting, it was an abusive position that he was doing, and that he should consult his senior management. I made it quite clear that he should, first of all, before contacting the courts, make his basically his seniors or his management or the CEO aware of what he was about to do, because I would be raising a complaint if he was to do that. So I clearly made it quite clear that he should not do this. And he had or chosen to basically inform the courts of this fact. So I don't know if your point number 8 clearly captures that, because it seems to be quite vague. But just to give you some further context, that this conversation between the issue of my litigation capacity was raised in a conversation with Mr. Barrett on the 18th of June. I then reasonably he wanted my input from this. I provided with my objections. I said it's only reasonable that, having spoken to you, and you've spoken to my barrister, that I should have an opportunity to speak to my barrister regarding this matter. So we had a conversation on the 18th of June, and then subsequently on the 28th of June, I had an opportunity to speak to the barrister to clarify the situation, that this is, you're both acting malevolently now. But so there was a delay of time between the 18th of June to the 28th of June, and so now the matter had been derailed, and so the hearing of the 5th of July's validity, or the purpose of it, which was established on the 20th of May, became nullified or irrelevant. And so therefore they had basically prioritized their own agenda, which was effectively the agenda of the local authority, to my detriment. So I hope that...
How do you think we should amend the complaint, please, then, Mr. Six? My understanding was that the complaint itself was that the barrister and your solicitor had consulted privately without you knowing, and then advised you that they intended to apply for litigation capacity without consulting you. So would you prefer it if I put the dates into that complaint?
Yeah, I think...
The firm spoke to you on the 18th of June to advise that they met privately with the barrister and that they intended to apply for litigation capacity.
Yes, I think I think yes. It seems a bit vague and abstract, so I think it does require a bit more. It does require a bit more detail, that they had consulted with each other prior to making me aware on the 18th of June. So that's an issue of concern, isn't it? It's like and then subsequently there was a delay until the 28th of June. So that could have been, I could have spoken to the barrister a lot sooner. But like I said, I mean, they could have concerns, like I can have concerns, anybody can have concerns. But I think the added caveat needs to be that in conjunction with the concerns, what had they done to prepare my representation for the 5th of June? Because it seems that they automatically knew that would be, like, their allegations would be given validity. But they could not know this, because the judge could have said, no, I don't accept that Mr. Hussain does not lack capacity, so I'm just going to ignore that. So if the judge had done that, then they had not prepared anything. Does that make sense?
Yeah. So in terms of your other complaints, then.
Okay. So
obviously the next complaint on the 7th references that that you met with them very briefly before the hearing on the 5th of July, which is inadequate time to prepare for the hearing.
Yeah, that's fine. That I think I don't have an issue with that point number 7. That's highlighted that obviously they didn't give me enough time, and it was just basically everything was an afterthought. Then I think they were saying, oh, it was like they were gonna prepare something on the day. Just so they could, but they had not. Their preparation should have taken place well beforehand, and that should have the focus should have been basically the court order, which had stated that a statement needs to be submitted by the 17th. They are not prepared for that. Then focus should have been how were they gonna represent me, or how they were gonna best represent me on the 5th of July. They had done something haphazardly, just as a tick box exercise on the day, or I think the day before or something, which was.
Yeah, to basically just say, well, we did meet with him, but actually the time that they met with you was inadequate. They didn't really spend much time with you.
Yeah. And it seems that they were not asking me what I wanted. They were basically telling me that, oh, this is what we've prepared, and what do you agree to it, regarding the injunction order. So yeah, I think I think you've captured that. Okay, number 7. But I just wanted to highlight that was the case. So that brings us up to the hearing on the 5th of June. the firm told Mr. Hussain they were not aware of the application for vaccine his mother had submitted on the 5th of August. This, I think, requires a lot of, this requires some amendment. Point number 8. Because what happened is that on the 5th of July, the judge conveniently kind of accepted what was being asked, and without issue. So basically, I've made an allegation regarding the judges being services being commissioned out. As a result of that, the solicitors have said, "Now we think you lack litigation capacity. That matters returned to court." The judge has said, "Yeah, I agree with you that obviously my services cannot be privately commissioned out." Effectively, that's what he's saying, and so therefore, what the hearing directions were that that obviously a capacity assessment of Mr. Hussain should take place. So that's what was obviously derailed for the 5th of July. So that was given our priority, because obviously at this stage there was the issue of committal proceedings. So the committal proceedings could not proceed, and all the other issues could not proceed until the issue of my litigation capacity could be addressed.
Yeah.
So what's happened on the 5th of July, an order has been drafted, but not actually given out. Obviously there's a delay from the order, from the hearing taking place and the order being received. Now subsequently, from the 5th of July, I have tried to speak to. So what's happened is that the committal matter, I believe, was listed for the 5th of August. Back in May. I'm not sure, but I think it was listed for the 5th of May. When we came to the hearing in in July, the 5th of July, obviously the priority now was for me to have a capacity assessment carried out, and so therefore the order was given. Now I had not spoken to Mr. Barrett. If I can just give me a second, I can just find out. So I had attempted to speak to Mr. Barrett following the hearing on the 9th of July, and then on the 16th of July. And then subsequently we had quite a lengthy conversation on the telephone on the 22nd of July. Now, the questions that I would at this stage asking was in relation to, well, wait on a minute, how has the order that we've received on the 6th, I believe sometime on the 16th of July, already given the name of the consultant? Because obviously the order, the consultant's name was not discussed on the 5th of July, because understandably you've just raised the allegation, or you've just made the courts aware. The courts have agreed with you that yes, a capacity assessment needs to be carried out. So I was asking these very challenging questions that this makes no sense to me. Who decided? Because the order clearly stated a named individual. That named individual was not raised in court. So obviously what needs to happen is that if on the 5th of July the courts have ordered for a capacity assessment to be carried out, what needs to then happen is that the solicitor, my solicitor, then needs to go through a tendering process of basically approaching numerous assessors, trying to find out availability, trying to find basically like going through a recruitment process. So I asked him had he had gone through this, and he said yes, I had. Basically the solicitor was stating that he had shortlisted the assessor. And I asked him for disclosure of this. Like, this doesn't make any sense. How could you have
Sorry, Mrs. This isn't. So you're talking about the litigation capacity assessor.
Yes.
But this complaint's regarding the vaccination, the application for the vaccination.
Yes, so this is exactly what I'm trying to explain. That I'm just coming to this aspect. So I'm just giving you some background information. So these are the complaints that I maybe missed out last time. Is that from the 5th of July, my issues with I was speaking, because now this is a priority. Me seeing my mother or the injunctions or everything else is taken less priority. The judges agreed with them that an assessment should be taking place, and I'm speaking to the solicitor regarding asking him challenging questions regarding the drafting of the order, how the capacity assessor has been selected. He's not providing me with adequate information regarding this. So the last time we had this conversation, which quite evidently he was stumped on, because it's all gobbledygook now. So the last conversation we had was on the 22nd of July, and it was nothing to do with the vaccine, nothing to do with anything else. It was simply to do with the fact that I was asking very challenging questions that he could not answer, which was quite evidently, I had basically highlighted that there was that the fraud was taking place. So I had a last conversation with Mr. Barrett on the 22nd of July, regarding the issue of the capacity assessment, so on and so forth. Now, in parallel to this, the following the hearing on the 5th of July, the local authority had instructed the clinical commissioning group to submit an application for a vaccine application. Now, the vaccine application had been received by the courts on the 20th of July. All right. Once the courts had received the application, neither I was not made aware of this, and neither, I'm told, Mr. Barrett was made aware of this. Then subsequently, following the CCG vaccine application by the clinical commissioning group, there was orders drafted on the 5th of August. All right, because I was told that the 5th of August was a hearing listed for my committal proceedings back in May. But then obviously in July, 5th of July, we were told that those were going to be vacated because my capacity assessment needed to be carried out. But what actually happened is that on the 5th of August, the CCG Clinical Commissioning Group's application had been accepted, and an order has been drafted and issued out by the 16th of August. So I'm then frantically contacting Mr. Barrett following the 22nd of July conversation. Basically, Mr. Barrett has told me that he now does not feel that there's anything further on the case, all right, that he could work upon. So he's basically told me that he's basically refusing to speak to me on the telephone now. He's advised me to put the things in writing, so I've both put things in writings and then persistently trying to speak to him on the telephone. Now, obviously, when he's telling me on the 22nd of July that there are no substantial issues, we are both not aware of this. And then once he receives an order, I think on the 16th of August, he tells me that, actually there was an order, I just need to make you aware of this order. And so now in August, he has received an order regarding the vaccine. And then he's told me that he was not even aware of it. So, but that was his responsibility. So, in response to this question of the vaccine, I think the number 8, obviously, I have concerns between question 7 and 8, further complaints regarding him not speaking to me regarding the assessment capacity assessor. But then subsequently, the vaccine issue, he's told me that there were no further developments, but obviously quite clearly and evidently there were. So obviously I needed to speak to him regarding putting in an objection to the vaccine application or any kind of like representation regarding this vaccine application. Now the further complaint I have is that I'm leaving now voice messages. So this is a further point of complaint that I have, is that from our last conversation on the 22nd of July, I've then proceeded to leave numerous voice messages for Mr. Barrett to contact me. So I think I have a record of leaving him a voice message on the 29th of July, on the 9th of August, on the 10th of August, on the 11th of August, on the 12th of August, twice, on the 13th of August, twice, on the 23rd of August, on the 14th of August, 25th of August, 26th of August, 31st of August. So basically, I'm leaving him numerous messages, and the next time he has a telephone conversation with me is on the 22nd of September. So my further complaint is that between the 22nd of July and the 22nd of September, I am leaving him consecutive, numerous, ongoing voice messages saying, talk to me, speak to me, and there are other issues that need to be discussed, particularly the vaccine question. All right, because obviously, and he's not spoken to me. And the only time he's then spoken to me on the 22nd of September was to do with the capacity assessment that he's received. So that is a further point of complaint, that between the time periods of 22nd of July until the 22nd of September, when he's told me on the 22nd of July, I don't want to speak to you because there are no substantive issues on this case. Evidently, he then became aware in August that there are further, court orders being issued out regarding the CCG giving the vaccine order, and obviously he needed to speak to me so I could challenge those orders. He's not contacted me, so that's a further point of complaint that you've not addressed. So I would like to include that.
Yeah, so complaint point 9 covers that the firm didn't provide you with any advice regarding the vaccination order despite your request for help. So should we amend complaint number 9 to include those dates that
yes,
the firm didn't provide you any advice despite your contacts between the 22nd of July to the 22nd of September requesting for advice?
Yes.
Do we amend complaint number 9 to include those dates?
I think that would be more, and I think it's not advice, particularly it's not responding to my telephone communication voice messages.
Okay, we'll include that then. Okay.
Yeah, right.
So we'll put that we'll put that the firm failed to return any communications that you made between 22nd of July to 22nd of September regarding an update of your case and advice regarding the vaccination order.
Yeah, but I think when you said communication, I think we were still in email communication.
Telephone communication. Should we say telephone communication?
Yes, or responded to my voice message, requesting a call back. But yes, telephone communication. I just think that point needs to be clarified, because just for your understanding, I just want to go off on a slight tangent to explain something to yourself. You've made me, at the start of this conversation, you've made me aware that this call is being recorded. That's correct, isn't it?
Yeah.
Okay. And have I made you aware in the past that it's my policy to record calls as well?
Yeah.
All right. So you're aware that I may or may not be recording this call?
Yes.
Okay. Now, you see, this is not a problem for me to state this. Now, one of the reason I mention this is that the main issue I have regarding this policy of recording calls, not only is it beneficial for me or for my reference purposes, it's also a dispute that I'm having with the local authority prior to for a number of years, because I deal with the social services, so the social workers, and often what happens is that they lie to me on the telephone or they lie to me in meetings. So it's my policy, whenever engaging with, particularly with social workers, but then more generally speaking with anybody in a professional capacity, over time I've developed this policy of recording conversations. Now the local authority are aware of this, and so I had, through their complaints procedures in 2018, made them aware that not only have I been covertly recording you in the past, which is my right to do so, which is not unlawful or illegal, the whole purpose of which is for my reference purposes. That question is muted if you're continuing to pathologically lie and manipulate. So I want in September 2018, I wanted the local authority to be made aware that I'm no longer going to be covertly recording. I want to overtly record you, and as a consequence, and obviously the local authority have a complaints procedure, and so therefore the only way I could highlight that was through their formal complaints procedure. And what I stated was that what outcome I want from the complaint is for the local authority to amend their council's constitution to recognize that all citizens, rate-paying citizens, have a right to record them, and so all the social workers should be aware or not object to members of the public or the people that they engage with to covertly record them. Because often what happens is that you may or may not be aware that often some people in a professional capacity say, well, I don't consent to you being recording me, I don't give you permission, and that is a moot point. That is an asinine point, because permission is not needed or required. So this is an ongoing dispute I had with the local authority back in September 2018. As a consequence of this, I believe that they have instigated initiated legal proceedings because they understand, taking legal advice, that what I'm saying is lawful and correct, and as a consequence they are required to amend the council's constitution. However, what they've chosen to do is circumvent that by obviously taking legal action against me and trying to effectively bring in a law that does not exist. Now, what they've subsequently decided to do is that they are then going to all their partners and associates and collaborators and telling them, do you know that covertly Mr. Hussain could be recording you? All right, so that therefore many people, especially if they're doing something malevolent or going against their better judgment or having their services privately commissioned, the last thing they want to do or are consent to or agreeing to is to be recorded. So what they've done is, so I believe that and so coming back to the point of that's the background circumstances, is that the local authority or the state agencies don't want me to record them, but they can't legally stop me. So what they do is they try to avoid speaking to me on the telephone. So I believe that the reason that Mr. Barrett refused to speak to me on the telephone and had asked me to put things in writing, which on the surface of it does not seem like a innocuous thing, it does not seem malevolent, but the local authority had concluded back in 2018-19 that they're not going to speak to me on the telephone, but they're forcing me to put things in writing. Now that in itself causes another problem, because you cannot have a policy specific, other people cannot have a policy specific regarding myself to circumvent me from recording and force me to put things in writing, because that then violates the Equality Act, because there's no requirement of me to put things in writing. So coming back to the complaints issue, the reason I believe Mr. Barrett had stopped, was refusing to take telephone calls on the telephone is because at this stage he had become made aware by the local authority not to take my calls and asked me to put things in writing to him. So I think that's a point that I just wanted to elaborate on, that point that that Mr. Barrett not responding to my telephone calls, it's not something that he did not feel it's appropriate or is going to give me another excuse. This for me is adding further weight and evidence, because Mr. Barrett, who's my solicitor, how is he complying with the local authorities' policy regarding myself? Does that make sense? So he's effectively.
We can amend that to include the dates and the fact that it was, you requested contact through telephone and this wasn't returned. We can include them in the dates, yeah.
Oh, okay, all right. So if you can just expand upon that. Okay, so the next one is the firm submitted evidence in the capacity assessed on the 5th of September 21. With respect, I'm not sure. This one is specific with dates, and to tell you the truth, I don't have the specific dates. I've not managed to review what the specific dates were. So I would like question number 10 to be a little bit more general, to the effect that the courts had ordered. I can't remember what order it was, but the courts had ordered for the capacity assessment to be issued out, completed and issued out by the start of September. All right, but the capacity assessment had not actually taken place until after the order date. So I think it's important, if you're going to include dates, that it should be included, clarified, that which can be further referenced, cross-referenced. What date had the order of the 5th of July stated that the capacity assessment needed to be completed by and handed to the other parties? Okay. And obviously I'm complaining that the Burke Niazi solicitors have not complied with the court order direction, and had attempted to carry out a capacity assessment after the event.
Okay, so do we reword it to say that the firm submitted evidence to the capacity assessor after the court order date?
Yes, I think that would be a little bit better way of phrasing. Yeah, because that can be then cross-referenced. Okay. Yep, because I don't have the exact dates with me, so I just wanted to just clarify that they had basically not, once again, I think this is a recurring theme here. Court orders should be complied with. I hope I don't think anybody is going to disagree with me on that. Neither yourself or the solicitors or anybody can justify why court orders are not being complied. Court order directions written down are not being complied with. So I think that's a further complaint in the category of court orders not being complied with.
Okay. Yeah, well, we can amend that, yeah.
Oh, okay, all right. And then it says the firm told Mr. Hussain he could contact the litigation capacity assessor to challenge the findings, but did not inform him this would be used as evidence of the assessment. Yes, I think what happened. I'm in agreement with point number 11 is that it was everything was like just before. Everybody knows when court dates are going to happen because it's preemptively put in place. The 5th of July, the 5th of August, the 1st of October, and obviously the coming closer to the date, the solicitors realize that they need to have the courts are gonna, the judges no doubt are gonna ask them why is the capacity assessment not carried out. So they basically rushed it through at the last minute, and obviously then then allowed me to speak to them on the 22nd of September. But like I said, then I said, look, reasonably speaking, I should have an opportunity to clarify this report, and therefore the assessor, so therefore Mr. Birknazi said, well, you can speak to him directly. So I think what I ideally would have liked would be a conference call, and I think I did mention this. I was expecting a conference call between me, the solicitor, and his expert, the assessor. However, he had simply forwarded those details onto me to contact him directly, and then subsequently told the assessor that this would be an opportunity for the assessor to further carry out an capacity assessment, considering he had never spoken to me before. So I think that point number 11 captures it. Yes, fines did not. Yep. And the firm did not share the transcriptions of the hearing, despite Mr. Hussain's requesting these. I think there are a couple of points that I maybe not have discussed. So I'm quite happy until the complaints that I had raised until the hearing until the 1st of October hearing. But I think there's a further issue that that there was no. I think the further point number 13 is that I had mentioned previously to you not being prepared for the hearing on the 5th of July. I don't believe there was any consultation between me and the solicitors and barristers prior to the hearing on the 1st of October. Has that been addressed?
I don't think we've discussed that as of yet. Like I said, point 12, I think what we confirmed. So just to clarify, you're happy with point 12, complaint 12?
But the point, I think there's a substantial, because point 12, just to clarify, there was a hearing on the 1st of October. During that hearing, obviously I was not, I represented myself. The solicitors and barristers were there simply to railroad through the lack of capacity issue. The vaccine question had been answered, addressed. So it was quite a very substantive full day hearing. As a consequence of that hearing, I had made the judge aware of sought permission to appeal, and the judge had advised, yes, you can appeal, and transcriptions would be made available. But the issue of the point number 12 of your complaint is that those transcriptions. So this was an issue in relation to the appeal application. All right. So the transcriptions were necessary for me to make an appeal to the Court of Appeal. You see, and so therefore, yes, that is a valid point, but there is a whole number of issues between the 1st of October and the transcriptions that were given to me at the end of December, right? That obviously is the point of the complaint, because during the hearing, the judge had stated that part of the hearing cost should be covered by my legal aid certificate, namely Birknazi solicitors, and part of it should be covered by the local authority. And so therefore, following the hearing, the point number 12 is correct, that the transcriptions were not given to me forthwith or I was not given any advice regarding when they would be given to me. I had made numerous requests for these over the intervening months. So point number 12 is correct, that there was no clarity of when the transcription would be given to me, considering there were a substantial amount of delay, and the solicitor did not press upon getting me the transcription. So that's a very valid complaint. But I think the complaint number 12, that should be coming down the list, because there are many substantial other issues of complaint that we've not discussed beforehand, that I wanted to have an opportunity to discuss between 1st of October and obviously until January 2020, January 2022.
Okay, so just to specify that the transcriptions that the complaints about, that they didn't share any of the transcription of the hearings, that's relating to the hearing from the 1st of October.
That's correct, yes, because
Okay.
I required the transcriptions in a timely manner to put in an appeal. All right. And
Yes,
so
yes.
if I can just come back to what's happened after the 1st of October. After the 1st of October, it's now become evident to me that I had refrained from discharging Burke Niazi's services prior to the hearing on the 1st of October, because I did not want to attend the hearing on the 1st of October not having any legal representation, and also not affording the solicitor an opportunity to give me appropriate advice for the 1st of October hearing. They had failed to do so. So subsequently, after the 1st of October hearing, I had made it quite clear that I had nothing to do. I had basically looked to discharge the services of Burke Niazi solicitors, and then subsequently, following the hearing on the 1st of October, I had then proceeded to lodge in a formal complaint regarding all the issues that I had raised beforehand. So then what's happened is that, with regards to raising the formal complaint, as you're aware, the solicitors have their own internal procedures, which is, first of all, I need to raise the complaint with the manager. That needs to be verified. Then a particular time frame is given of when the complaint would be dealt with. So then I started to raise the complaint on I believe the start of October sometime, regarding all the things that what we've discussed up to this point. So however, the solicitors were then informing me that I no longer am in a position to dissolve the contract or relationship, or instruct them, or basically discharge them, because at this stage they had now decided that the case is going to continue through the involvement of the official solicitor. All right, so they told me that the official solicitor was going to be now dealing with this situation, so they were no longer willing to take instructions from me. At this stage, following me raising a formal complaint to Burke Niazi solicitors, I then proceeded to make my second subject access request for full disclosure of the records, because as far as my understanding was that the relation should have ended, but they were saying the relationship is continuing. So therefore, I then made a formal request for disclosure of records, which was not complied with. So I then wanted to ideally raise those as further complaints, but I could not do so because there were already ongoing complaints, and I attempted to raise these as further complaints through the complaints procedure, but because it was a very unique set of circumstances where the relationship was effectively still continuing and the relationship had not ended, and there were complaint procedures ongoing, and so therefore obviously this was on a point of issue. But then obviously following the hearing on the 1st of October, I was then liaising not with Mr. Marcus, not with Michael Barrett, but with David Marcus, which is the complaints manager, to finalize what the complaint should have been. He was then corresponding with me in writing regarding the complaints procedure. But subsequently, there was an issue of the appeal that needed to be addressed. Now, and hence why I think one of the points of the complaint is that at this stage, in the earlier on in this conversation, you've told me that these further complaints needed to be put to the solicitors because they've not had an opportunity to address them, and that's hence why the case has, your case, our case, this case has been suspended. But the reality is that I was not in a position to provide these as complaints because there were ongoing issues. So in relation to this matter, the complaints I have, which I think you put that to the solicitors, is that I had then attempted to ask for. I told them I don't want you to represent me in the appeal case, which is a separate case. But however, the solicitor, Mr. Barrett, was trying to convince me that I should work with him in order to put the points across to the official solicitor. Basically, they had looked to circumvent my instructions to them and were trying to railroad me into using the official solicitor, which obviously I had objected to. But hence, this is one of the reasons that I was trying to explain that I had then said, look, I don't want you to deal with the appeal. You're not required to deal with the appeal. You're dealing with the case, so give me the information regarding the other solicitors, particularly my mother's, particularly the official solicitor's representative regarding my mother, and he would refuse to give me this information. So that was the extended point of the complaint, which is now you're forwarding on to them. So, but also what had happened is that I then had certain questions that needed to be addressed and answered and these questions were more to do with the disclosure of records. So I then attempted to speak to Mr. Barra and left him numerous messages with the reception all throughout November, all right, asking for a call back. So whereas previously between the 22nd of July and 22nd of September, I had left voice messages, so he was picking those voice messages up. Subsequently, between in October to throughout the month of November, I was leaving messages for him with the reception staff, and he was not returning those messages to me. So in the category of not failing to communicate with me, this is a further incidence or a further complaint that between I would say between maybe the start between the start of October, maybe between the start of October until I think until the 8th of December, numerous not voice messages but messages were left with the reception staff to contact me. So there's once again another a period of over 6 to 8 weeks where Burke Niazi's solicitors as a firm are not responding to me, because at this stage I not only want to raise the issue of complaints verbally or highlight further issues. The issues of concern I have is in relation to the disclosure requests not being met and disclosure not taking place. So my further point of complaint is that between the start of October until the 8th of December, the Mr. Barrett and the data protection officer had not got back to me. So that's a further point of complaint there. Okay. And then obviously when I had spoken to Mr. Barrett for the first time, subsequently following the hearing on the 1st of October, to asking him numerous questions of irregularity, and obviously where effectively he could not answer those questions because he was kept on contradicting himself through the versions of events that he were giving me. So in that lengthy conversation, which was because at this stage, following my raising a formal complaint with regarding Mr. Barrett in October, I did not feel comfortable speaking with Mr. Barrett in private anymore. Hence why I was no longer ringing him up and leaving him voice messages, because a live complaint was ongoing that I had raised in October. I did not feel it appropriate for me to be speaking to Mr. Barrett in isolation. So I wanted to have a third party from the firm to be present so I can speak to him. So that's hence why I was in the month of October and November. I was not leaving him any voice messages because I was not trying to contact him directly. What I was trying to arrange is a conference call with him, and to have another person with a witness. That first conversation took place on the 8th of December, where I had challenged him on basically all the issues, some of the issues that I had raised, and tried to highlight to him that, look, you give me your version of events. How did these things happen? Like, how did the capacity assessor get a hold of a YouTube account that I had never given you, and why had he not been given the YouTube account that I had given you as part of the assessment process? So I had asked him some very challenging questions which would have effectively highlighted his fraud and deception and collusion with the local authority. So he could not answer those questions, and asked for some time to obviously consider those questions. And so I had a conversation with both Mr. Michael Barrett, and Harriet Kaiser, which is the data protection officer, on the 8th of December. And then I believe I had a further conversation with him on the 13th of December, where he could not answer many of those questions. And at that stage, on the 13th of December, I had told him, well, wait on a minute. One of the issues that's still outstanding is where is my the transcriptions. Those transcriptions we should have gotten by now, and I've already put in the appeal application, and I don't want your involvement. So obviously he became aware then that the transcriptions do need to be provided as per the direction of the order. The order of the 1st of October had not given a date, but they had obviously once again failed to comply with court orders. So this complaint, I think, is in relation, the transcription issue complaint is all in relation to a failure to comply with court orders again, and not pressing the other party to finalize the transcriptions. So I just wanted to bring that to your attention. And then subsequently, so that's a point of complaint there, is that Mr. Barrett had not responded to not voice messages, communication left with the reception staff, and not arranged to answer these questions. Does that make sense?
Yes, so you want that reason as a separate complaint,
Yep.
a lack of communication between the start of October to the 8th of December.
Yes, through the reception, not voice messages. So yes, that's a further complaint. Yes. Yep. And then obviously, what's happened then is that from the 14th of December, when I last left a voice message, throughout the month of remaining months of December, until January, until actually the 20th of January, I have not had further communications with the solicitors at all, because considering they said that Mr. Barrett said he's going to look into these points that I had raised and going to get back to me. He had not got back to me, and obviously I think that's a point that that's going to be further given to the solicitors, is that there was no, as I explained previously, at a court hearing, one of the things that happened towards the end of the court hearing is further directional hearings are given of when the case is next going to be in court. Now, on the 1st of October, when I had challenged the Mr. Justice Cohen regarding the fraud allegations directly to him, I had asked him the question in court on the 1st of October, what are my options? The same advice that I had sought from the solicitor and the barrister regarding him privately commissioning out the services unlawfully to the local authority. I had asked that question directly to Mr. Justice Cohen on the 1st of October, and as a consequence he said that's nothing to do with me, and effectively abandoned the hearing. He had not listed the case to be next heard, all right, which was obviously a failure on the part of the judge. And also, so in December, I was not made aware when the next hearing was to take place, and the solicitor was not communicating with me on this matter. And however, he had then subsequently put in an application to the court of protection in my absence. So I think this is a category of complaint that I would like you to further list, that from my giving him instructions or effectively looking to retain his services from the 1st of April until the end of December 2021. He had not put in any applications to the courts on my behalf at all. And yet there were many opportunities, and I had requested him to put in applications as my representative. First of all, regarding the final hearing, my right to appeal, or in regards to the vaccine question, or anything. So as a category of complaint, what I want to say that under my instructions, he had never put in an application to the courts on my behalf, but had only responded to, only attempted to respond to applications submitted by the other parties, namely the local authority or the clinical commissioning group, and had effectively failed to respond to court orders. So I think that is a category of complaint that I want, that he had failed to take instructions from me and put in court applications, but yet had taken instructions from the official solicitor, whom I had not liaised with, in order to put in a court application in my absence and awareness. And I think that's one of the points that you've already put into the solicitors. Is that correct?
Well, if one of the complaints is that he didn't submit an appeal application, we can add that complaint on, but we need to be specific about what appeal application it is.
No, we're not talking about the appeal application now. Okay, I mean, like I said, I was going to submit the appeal application myself, and he was not providing me with the support, evidence, or information that I required to assist me, namely the names of the other solicitors' contact details. So he did not provide me with that information regarding my appeal application. But remember, the case has not been concluded with. It's not finalized yet, or it's not been stopped with. All right. So one of the questions, one of the things that I'm complaining about is that as representing me, he had never put in an application on my behalf. All right, in the main case, at any stage throughout from April to December. Does that make sense?
What is the application for? What do you think the applications were that he should have submitted?
There were numerous. Obviously, there were. Just to clarify, it's not the fact that It's a fact that he did not submit any applications. So one of the applications obviously is to do with asking me the question of what I want. What are the things that I want that the court should be aware of? Like, for example, he did not submit an application to the courts regarding, my need to see my mother. All right. Remember, one of the reasons I had approached the solicitors is that I was being prevented from seeing my mother. Basically, he had not spearheaded my agenda through contacting the courts on my behalf on many points of that needed to be applications needed to be made. He had never responded to the courts with a new application on my behalf when I had ideally would have instructed him to do so, had the opportunity had arisen, had the opportunity not been basically circumvented from me to doing so. So, for example, from the 18th of June onwards, because he's of the position that I lack litigation capacity, he's effectively not in a position to submit any applications that promote my agenda or narrative. All right. And so he effectively, from making that allegation or having a belief that I lack litigation, he's not going to be submitting any other applications. And that is a failure on his part. But then when the official solicitor has been railroaded to represent me, he's then looked to then submit a proactive application to the courts in my absence, which was effectively the official solicitor had stated that she was not happy to represent me on the basis of the capacity assessment that had been procured by the solicitor in September, because evidently the capacity assessor had not spoken to me or had not even had contact with me. So on this basis, when it was to do with the agenda and narrative for the best interest of the solicitor and the local authority, had he submitted an application in January or at the end of December, early January, to the courts in my absence or an awareness, requiring or forcing me to undertake further assessments, those were not consulted with me. That basically what I'm trying to state in this complaint is that when I last spoke to Mr. Barrett on the 13th of December, he had not made me aware or advised me that because of the new circumstances, that now you are officially represented by the official solicitor, and the official solicitor has raised these concerns with us, stating that they would like something more comprehensive regarding a capacity assessment that I intend to apply to the courts. He did not feel it necessary to inform me, and yet had done so without my absence, in my absence and awareness, and effectively was was not looking to engage with me. So I think as a category of complaint, I'm trying to state that there were many missed opportunities for the solicitor to put in applications in the main case to represent me, and he had failed to do so because of his agenda. But then when the official solicitor, it was in their beneficial interest to continue to represent me, because obviously they were going to get more money, that they had put in an application in my absence and awareness.
Yeah, I mean, we can't put down such a vague complaint. If the complaint that the firm haven't acted in your best interest, that is too vague. If you instructed them to submit an application and they didn't do it, that's a perfect complaint. That is a failure of service. If your complaint is just that, well, I don't think that these submitted applications, appeals are acted in my best interest, throughout the instructions, that complaint is too vague. We'll need specific examples of, for example, I said, if you ask them to submit or carry work out in order to put an application in to see your mother, and they didn't acknowledge or respond to that, that's a specific complaint.
With respect, Sian, what you're asking, there's two aspects of a complaint. A complaint could be commission or omission. What you're asking me to now is that can you, and as you can appreciate, when you commission something, it can be codified and verified, and is can be substantiated. So commissioning of something can be codified. Omission does not, by its very nature, it cannot be evidence, because the reality is that what my complaint is not of the fact that they failed to they failed in the commissioning of my instructions. What my complaint is that they had failed in the omissions of submitting applications with myself, because of their failure to engage with me. So just to expand on this point, in order for them to commission something, they need to engage with me. It's not an issue of their negligence and an issue of failure to do something. The very complaint is one of omission. Now, one of the complaints in this regard is that I was asking them, and I don't think this has been captured in the previous complaints raised with you. I had asked them specific questions, all right, which can be codified, which were written to Mr. Barrett in writing, all right, which were not formally responded to me in writing. So, for example, I had asked Mr. Barrett certain questions. For example, I asked him the question, can you tell me in writing when it got established that my mother lacked litigation capacity? Those were the questions. So throughout the period that I've spoken to you about, where Mr. Barrett was not speaking to me on the telephone, or we were not communicating on the telephone, did not prevent me from communicating or engaging with Mr. Barrett through emails. Now, I'm not going to list here every single question that they failed to answer, because there were numerous questions, but the general question being is that if I had an opportunity to consult with them and had these questions answered, all right, then I would have been best positioned and prepared for them to clearly articulate what applications I needed for them to make. But for them to simply not engage with me and not answer my written questions created a situation of omission where they were not able to represent me adequately because they were omitting a certain omission of service. So when I'm stating that they had not put applications in, and you're stating which applications, well, there were necessarily an opportunity for me to put in several applications. For example, let me give you another example. The clinical commissioning group had submitted an application to the courts because they wanted to get my mother vaccinated. I ideally, in an ideal situation, would have submitted a counter application objecting to this. But that opportunity was never afforded to me because obviously the solicitor said, I don't even know about what's happening here. All right. So because of their failure to, it's an aspect of omission. So I can't then say that, oh, I told you to object to this application because I didn't, because I was not afforded the opportunity. But that does not then, it's like, I think with respect to yourself, I think the focusing on commissioning of services is quite clearly tangible, but the omission of services is not something that's easily tangible, hence why I'm making the statement in the abstract that so I'm trying to capture it that there were omissions made by the solicitors because they had failed to submit any application on my behalf from April to December, and that is an aspect of omission. There is no specific application because I was not afforded the opportunity. But can you understand, if they have omitted to do something, that's still an aspect of negligence of service, which I cannot capture in the quantified instance, but I can specifically state that there's a general complaint of omission of services. All right, the omission being that which can be evidenced by the fact that, wait on a minute, throughout the period of April to December, when there were several concurrent cases running, namely the injunction orders, namely the committal proceedings, namely the vaccine question, namely the ongoing care proceedings, 4 or 5 cases were running concurrently, all right? And the role of the solicitors was simply to act as a respondent party to the other applications in place. They had not acted through their failure of omission to ask me what I needed to have happened. All right, so appropriate applications could have been put in place. So, for example, one of the first things I had asked the solicitors to do is to appeal the final hearing, which I had not attended. So the solicitor then sought advice from the barrister and simply stated that there's no grounds for appeal because we're out of time. So that is a very simple thing for them to do. However, ideally, in order to establish, because the hearing had happened in February, the solicitors had been contacted in April, May, June, and they were not party to the proceedings. So ideally, what should have happened, any reasonable solicitor, what they would have done is to say, well, wait on a minute, we did not attend these hearings, we do not know what happened, we do not know if there were reasonable grounds, we do not know what arguments that were partaken in these final hearings, which lasted 5 days in the middle of February. So the first application they would have had to make is to ask for transcriptions of the final hearing, because obviously at that stage, any solicitor, even I as a layperson, can understand that, well, wait on a minute, we did not attend the final hearing, we do not know what happened, our client did not attend the final hearing. Obviously there are very draconian orders put in place. We need to understand what's the legal basis of these, and in order for us to advise our clients, we now need to make an application to the courts asking for transcriptions or the hearing, so we are aware of what happened, so we can appropriately advise our client that, wait on a minute, the final hearing, this is where legally they failed upon, this is where it can be challenged. They did not do that at all. They always acted in their own financial interest and looked to quickly circumvent my beneficial interest by simply stating, oh, you're out of time, therefore you do not have grounds. Yes, I understand as a layperson that all appeal applications should be submitted within 21 days. However, appeal applications are known to be submitted outside of time if reasonable grounds can be given. They did not even entertain such a notion. They simply said, we're not even going to entertain that idea. We don't want you to, basically you can't appeal. That's it. End of. All right, effectively. All right, and then subsequently, because they had failed to come on board at an early stage, there were now concurrent committal proceedings. So they needed to put in applications on my behalf to look to vacate the committal proceedings or undermine the committal proceedings. They didn't do anything of that. So there were my general point is a one of omission. Between April and December, they had not made any applications on my behalf to put forward my agenda to undermine the proceedings. It seemed quite evident to me that all they were looking to effectively do is to look to adhere to and respond to other people's applications, namely the local authorities' applications. So with respect to go on.
No, I appreciate what you're saying, Mr. David. Basically, complaint is that they didn't really act in your best interest. You didn't pursue, things that you expect them to pursue, throughout the whole time that you had with them. But the issue we've got with that is it's too vague of a complaint. But what we would do is, whilst investigating these complaints, we would look at the implications of the poor service. So if all these complaints, I find that there was poor service, the firm did not act reasonably, I would then take into consideration that had they acted reasonably, you would have been well informed, your case would have progressed well, and that would have opened opportunities for you to potentially have been more successful in your cases, which is what you're saying. So it's something I'd consider when looking at the impact of the poor service, but it's not a specific service complaint, if you will.
Okay. Well, the thing is, that's from your perspective. I'm not obviously that you're more competent in dealing with how you looked into the matter. My overriding complaint is not that, you can have poor service, and the question you need to be asking is, why is there a poor service? Is it a failure of competency? Is it a failure of lacking of resources, not having the right training, and so on and so forth? But under these circumstances, my overriding complaint is that the poor service was not a failure, but was deliberate and was contrived and was malevolent. So that is the overriding, I think, theme that I've been saying to yourself, is that this was a poor service. Like, for example, like if let me give you an example. Let's say if you come to me and I'm a car garage and stuff, and obviously that can be, but if I target you and I think, well, I'm going to go out of my way to provide you with a bad service, then you cannot say, oh, it was a bad service. It was deliberate. And so here what I'm trying to explain to you is that the solicitors' overriding objective was to maximize financial benefit for themselves. Okay, that is obviously what I would expect from your findings, is that given all the complaints and all their arguments and all my arguments, the overriding thing is that, was the solicitors effectively looking to maximize profit and gain for themselves over and above the interest of the client? So can you understand, as a solicitor's firm, if the opportunity was afforded to them to quit the case, all right, so on the first opportunity, so basically for them to do an effective job, they could have said, well, wait on a minute, this case has absolutely no legal merit, we're going to put in an application and we're going to have this case thrown out. That in itself would have minimized the financial gain for themselves, because they would have effectively ended the case. But for them to say, well, wait on a minute, we don't need to do that to the detriment of the client, because if we can say that, oh yeah, their case is legitimate, we can get more money out of this. So ultimately, my overriding and overarching complaint, which is obviously going to be an outcome of your investigation, is that the solicitors firm were not acting in my best interest. They were acting in their corporate best interest to basically string the case along, or to find out ways to maximize that the money that they can make. And this, as you can appreciate, as you as the ombudsman must take this matter seriously, because this is not my personal money. This is not my own financial money or my hard earned money that they were basically trying to swindle out of me. They were effectively trying to swindle out of the public purse. They were effectively trying to use me as a legal aid mule, trying to get money out of the legal aid system unnecessarily. And that is a far more serious allegation from your perspective as the ombudsman, to state that, wait on a minute, we are now because this time and resources of your investigation is taking up public money, all right, because this is at a public expense. And has this solicitors, yes?
And obviously I understand what you're saying, because we've discussed it quite a bit in terms of what you think the true motive was for the poor service, and I will keep that in mind whilst carrying on the investigation, of course. But what I'll do is I will amend the complaint points of what we've discussed, and I will send another complaint confirmation letter to you, just to make sure that I'll amend them, and then you let me know if you're happy with the wording. Okay.
Okay.
In terms of the premature complaints, obviously you've just raised another issue there that you want to take forward about that you left messages between the start of October until the 8th of December. You left messages with the reception, and you never had the call returned to you. So, that's another complaint that I'll have to double check to see if there's any record of that previously being complained about. But that may also be what we call a premature complaint. So I'll just want to discuss this with you if I can, Mr. Singh, so you understand obviously where we come from and what a premature complaint is. So our role is to investigate complaints that have already been complained about to the service provider. So those 12 complaints that we've just gone through, those are issues I can see that you've already complained about. Now, the other 3 issues and this additional issue that you've just raised with me, I can't see has been previously complained about to the service provider. So our kind of rules and what we normally recommend is that firms have up to 8 weeks to have an opportunity to respond to any complaints. So I put forward to the firm in terms of these premature complaints, and they have asked for 8 weeks to consider and respond to them. And then ultimately what will happen is I will share their responses with you. If you're satisfied with their responses, then we won't take them any further. If you're dissatisfied with their responses and you feel it doesn't answer those complaints, we will include them with the other 12 and then take them forward to the next stage of the investigation.
Okay, well, thank you for that clarification. But as you can appreciate, the reason, I mean, what you're asking for, what you're stating is quite reasonable and equitable. However, that reasonable and equitableness is not relevant here, simply because that, as I explained, I raised a complaint in October. Those issues, because the problem here is that if ideally those complaints should have been at the end of service. Now, these retrospective complaints that you're saying is as a failure, not on my part. It was that I was denied the opportunity to further have these concurrent complaints amended, because how the solicitors firm have done it is that they have all right, we've received the complaints. That's the end of the further complaints. Basically, the solicitors firm, we're talking about now, Mr. David Marcus. I had attempted to engage with him to add these further complaints while the 8 weeks complaint evaluation was taking place. And the further complaint, I guess the category of complaint that I have is with regards to the procedural methods, is that whilst the complaint was lodged with Mr. David Marcus in October, I had actively refrained myself from further engaging with Mr. David Marcus, Mr. Michael Barrett, the solicitor, because I didn't want there to be further escalations of ongoing issues. But because of these circumstances that there were ongoing issues, the solicitors firms did not make me or did not would not engage with me to take on these complaints. So I had made Mr. David Marcus aware that there are other complaints that I need to be addressed, and he was saying, well, let me deal with these complaints. And so I feel slightly aggrieved that now at this stage, the procedures and policies that you have in place are effectively trying to state that it was incumbent upon me to raise these complaints. But once again, I was following policies and procedures which effectively, under unusual circumstances, I don't think those policies and procedures that are ideally for normal circumstances were relevant in my circumstances, because I was trying to highlight these complaints need to be investigated. So so I think it's like slightly unfair upon myself that that I was not given an opportunity to raise these complaints, because there was a live complaint ongoing that were being investigated, all right, which would have further added to the deadline date, which is clearly not what's happening now. Is that if in October I raised these complaints, I had then subsequently attempted to raise further complaints with Mr. David Marcus, who would refuse to engage with me, they would have then effectively put the deadline date even further and further. And ultimately what the solicitors wanted to do was finish with the deadline date as quickly as possible, because at this stage, throughout the process of 8 weeks, the case had effectively ended. So there were other issues. Now, you've made me aware that, look, I'm just given this one opportunity now to add in further complaints, and hence why we're having this lengthy conversation. And this only takes us up until January. However, there's a further complaint, which obviously I could not do until the case had been finalized, which was also in relation to, I still at this stage, which I think has not been captured by yourself, is that I still don't have disclosure of the costs. So in order for me to substantiate my allegations that, look, this was all to do with costs, that I had rang a further complaint is that in January and February, when I had spoken to the solicitors, again, Mr. Barra and Harriet Kaiser, I had asked for disclosure of the records. And the further complaint is that they've told me that we have not finalized the case as yet. The case ended when your mum died, but however, we've not finalized our costs yet. And the other complaint that the last opportunity I'm going to have is that, ultimately I need to know how much money they've made, and they've not provided me with that complaint. Now, at some stage, would you agree with me that at this stage of issues, that now that I've raised the complaints and to the Ombudsman, they're under investigation. I'm not under any investigation, am I?
Well, no, you're part of the investigation. You brought the complaint.
Yes, but I'm not the one that's under investigation. Is it clear that they're under investigation?
Well, to be clear, Mr. Singh, nobody's under investigation. There is a investigation going on regarding you've made a complaint. So like I said, everything's kind of 50-50. We expect complainants to bring evidence to us to support their complaints. We expect firms to also provide evidence to support that they gave a reasonable service. So nobody's under investigation. There is a investigation into the complaints that you've made.
Well, maybe it's a difference in terminology. My understanding is this, and maybe you can correct me on this, or maybe I'm mistaken, that they are under investigation. And they are being investigated by an external party, which is yourself, the Ombudsman. They are under investigation because a member of the public, a client, has raised an allegation. So they are the one. So basically, what I'm trying to state is that because they are being investigated. Their affairs are being investigated. Their conduct is being investigated. Basically, because I've raised an allegation, they have to now justify the actions that they've taken. So when I say the terminology that they're under an investigation, what I mean by that is that a complaint has been lodged against them. All right, an accusation has been made against them, like any kind of person can have an accusation made against them. They are now being investigated to establish whether the allegation or complaint or a grievance has any validity. The point that I'm trying to make here is that they have to justify what they've done. I don't have to justify anything, do I?
Well, I do expect when it moves to the next stage of investigation that you provide evidence to support your complaint.
Yes, that's fair enough.
To support that they gave you a poor service, and then obviously they will provide evidence to provide, to support that they gave you a reasonable service.
So let me just clarify. Are you a judge then? Are you acting as a judge or an investigator?
Well, we're investigating.
Yes. So you're not. I don't have to provide you with evidence, quote unquote evidence. I can assist you in your investigation and provide you with evidence, but I don't have to prove anything to you. I don't think. What has to be proven is the evidence. The evidence would prove whether my allegations are factual or not. The evidence would exist or not exist, which concludes whether my complaints are valid. I think, just to wrap up this conversation, I'm just trying to establish that at this stage, the solicitors firm are being investigated by a regulator, which is yourself. As an ombudsman, they have to basically justify, well, this is what we did and this is what we didn't do, this is how we did it.
So just to wrap it up, because I do want to just discuss the premature elements of the case, Mr. Singh. So, like I said, just to clarify, we're not here to investigate their conduct. We're not here as a regulator. That is the SRA, so that's the Solicitors Authority regulation. They will look into alleged complaints about conduct. What we're here to do is here for consumers, for individual complaints. So in this case, there are complaints about poor service. So if we come across during the investigation any concerns about their conduct, severe concerns about their conduct, we would make a referral to the SRA.
Okay.
But we're not here to audit their full conduct. We're here to look at the service complaints they've brought to us.
Okay.
Now, in terms of premature complaints, like I said, the way we think firms should have up to 8 weeks to look at any complaints that are alleged to them. From my looking through the correspondence I can see, I can't see that these three issues and this new issue that you've raised about the contacts between the start of October and the 8th of December have previously been raised to them. Now, I understand what you've said about the circumstances and that you didn't have opportunity, and I appreciate that, but we still have to give the firm
Okay.
respond to them. If you don't want them to have 8 weeks to respond to them, we can withdraw those complaints, and you don't have to give them that opportunity, but then we wouldn't investigate those complaints. So if you want us to investigate those full complaints, we have to give the firm up to 8 weeks to respond.
Okay, that's fair enough.
Give you a chance to review their response.
Okay, that's fair enough. I mean, those are your procedures, which I'm looking to comply with. But just to clarify, I stated that the firm had not contacted me back from October to December. I had also stated that I left voice messages from the 22nd of July to the 22nd of September as a further complaint. That's been captured, yes. So I need you to just capture that, yes. But the point I'm trying to say is that at this stage, just as a final point is that at some stage, as an aspect of resolution, one thing that you can ask as a resolution to put to the other firm is that, look, the case file, irrespective of how extensive it is, has to be handed to you, no?
No, we can't. That's not what we would do in terms of remedy.
Okay, all right. But as a terms of remedy, if I lodged a complaint and you're asking me for information, basically I don't understand why now at this stage, because it's not simply the solicitors firm have simply not ended the case, got the money and filed the case away. This is a live investigation, all right, from yourselves, all right. So it's still a live investigation. They have this case file. Could that not, if you're going to contact them again with these extra complaint points, one of the issues you can say that I as the client are still asking for full disclosure of the case file, all right? because obviously they have because that would give me then a point of reference where I can say, well, actually I can't remember a year ago what happened, that they've got this information and they can provide me with that information. And most importantly, like I said, one of the complaints that are like a delayed complaint is the fact that they told me that we can't disclose the costs. So I think they applied to the courts for the cost from legal aid in maybe April May this year, last year. So they've not provided me with that information, and they're not giving me any avenue to forward that. So if you're telling me that, oh look, you're waiting for a response for them, and ultimately you're explaining to me that you're acting as an impartial arbitrator, and ideally what you would like to see is for us to both hug and make up and be resolve our grievances. Well, one way forward as a goodwill gesture or as an act of professional courtesy, which a question that you can put to them, that the matter can be de-escalated straight away. It can be, I would be more compromising of their responses if at this stage they can do what they were supposed to do and provide me with full disclosure. At least that's a remedy to the grievance I have, because the overriding grievance I have is that, look, they're still holding my data, my information. I do not know how much money they made. And that's important for me to understand, that was this motivated by these factors. So I don't understand how yourselves, you could, as an impartial party, cannot simply ask them that they can say, no, we don't feel it's appropriate to do so, or it's going to cost us too much money, or X, Y, and Z. But I think at this stage, they do need to assist you in your investigations, and as part of that assistance, they should look to hand over, the case file to yourself. Now you can't force them, probably you're telling me you can't, but ideally, if they've not done anything wrong at this stage, the question of their legitimacy, or the question is being put over their motives and actions. So they are then under investigation and need to justify what they've done, and they have the records, and by them holding on to this information and failing it to give it to me, adds weight and gravitas to, look, hey, if you've done everything open and transparent, everything correct, be open and transparent. So this is an issue of complaint, that they are effectively being stonewalling me at every corner, and by refusing to disclose, I will get the records one way or another, even if I have to take legal action against them. But it's advisable for them that the case file records that they're holding on to now, they've got paid for from the legal aid agency. They are my records, and they should hand them over to me and be open and transparent at this stage, because by their failure to be, they can say, no, we don't want to, but that adds weight and gravitas. So why are you not being open and transparent to me and handing over the case file, so I can determine what exactly has been happening, and I can assist you also in the investigation process by, if they're giving you some information, just a final point, if they do disclose information to you as part of the investigation, will you be disclosing that information to me?
Correct, yeah. So let me just briefly respond to what you said then, is to say, if you want me to ask them to provide you with a copy of your entire case folder, I can ask that.
Yes.
They're not obligated to do so, but I can ask that. I understand that you've got a separate subject access request in with them, so I can ask that they're trying to respond to you regarding that. But again, they're not obligated, but I can definitely put that forward.
But can you get me sorry to interrupt, but can you get me a definitive answer, then whether they will or will not? That's all I'm asking. You ask the question, and if they can provide a definitive answer, yes, we will fully be transparent, or no, we will not, or we will be partial transparent. Can you give me an answer to that?
Yeah, I could. Yeah, well, I've got to put these new complaints to them, so I'll ask the question, absolutely. Two, you've mentioned a complaint regarding the fact that they never disclosed the full cost to you. Again, if you want to include that as a complaint, we can look at that as a separate complaint if that's what you want me to include. So
yes,
the firm didn't disclose any final cost to you. I can include that and put that to them, alongside your
yes,
complaint here about the communication,
yes,
messages, etc. I'll include that as a separate complaint on its own, okay?
Okay, that's fine.
And three, just when we make an evidence request, I will ask for specific pieces of evidence. The firm will supply me with anything that they think will help support them that they've made a reasonable service. At the end of it, if I come to write my case decision, I will disclose to you and the firm evidence that both of you have provided that has helped me make my decision. So we're transparent, all transparent. We're showing you exactly what evidence we're using to make our decision.
Okay.
So you'll see all that if it gets to
Okay.
a written case decision. Okay.
Okay, all right, that's fair enough. But like I said, you can ask for specific pieces of information from the solicitors, can't you?
Yes, correct.
All right.
That's what I'll be doing.
Okay, all right, okay.
When it comes to requesting evidence.
But you can also ask for all the information, can't you?
Well, I wouldn't. I can ask if you're asking me to request it for you. I can mention that in my email to them when I talk about the other 2 complaint points for them to look into. I can say that Mr. Zane's request that you share the case file with him, and I'll share their response with you.
Yeah, that's fine.
I won't be asking for the full case folder because there will be stuff in there that's not necessary.
Yes,
for the
okay.
investigation.
But can I just from your perspective, you have the authority to ask for specific pieces of information to help you with your investigation. You have the legal authority to do so, don't you?
Well, yeah, I can ask for evidence, but
No,
if they don't provide
no,
it,
no.
what I would do is just...
No, what I'm trying to say is that you can ask for specific pieces of evidence to help in your investigation. Do they have to provide you with any? Do they have to assist you and provide you with anything?
No, they don't have to, but they should, because if they want to defend it, they gave a reasonable service. They should.
Okay, all right. Do they have any legal obligations to engage with the investigation process?
They should engage with us.
No, do they have
Absolutely.
Do they have any legal obligation?
Yes, they have to engage with us, but they can choose. They can turn around. If they turn around to me and said, actually, no, we have no evidence to submit it, then I can't enforce them to send me anything.
Oh, no, that's fair enough. But you can ask for specific pieces of information, and they have to respond. You basically, irrespective of what they do.
They have to respond.
Yeah, so you can ask for specific pieces of information that you feel would assist you. In that same authority, you won't be doing, but you can effectively ask them for the whole of the case file, can't you? I know you won't. I know you won't. I know you won't be doing that, but you can ask them for the whole case file, can't you? As part of your investigation.
No, we can only ask them for pieces of evidence that relate to the complaint point.
Okay, so you can't ask. You have no authority to ask them for the whole of the case file.
No, we have no authority to. Listen, we can ask for evidence, but they are under no authority or obligation to provide any.
Okay, all right. So fair enough.
But they have to engage with us, so I'd at least expect them to come back to me and tell me that they're not going to provide anything if that's what they want to do.
Okay, so
we can absolutely ask them.
Okay, well that's.
On your behalf.
Okay, well, Ken, I think we should look to wrap up the call right now because we have been on this call for some time. But just to summarize, I just feel the fact that your organization as a whole, and no criticism to yourself, is a toothless organization and has no real weight and gravitas behind it all. Because if you can't even oblige them to submit evidence to yourself, because that's what you're telling me, they're under no legal obligation to submit any evidence to the Ombudsman. Well, that just shows me the fact that it's just basically a toothless organization, just a front. But that's obviously my opinion that I've formulated after speaking to yourself. But irrespective of this, I'll leave the matter with yourself, and I hope to hear a response, a positive response from them, because they cannot retain and hold my case file indefinitely.
It'll probably be tomorrow now, Mr. Dave.
Okay, that's fine.
A correction to the complaint. I'll amend the complaint. I'll send you a copy.
Okay.
And I'll include in writing what we've discussed today, okay?
Okay, that's fine enough. Thank you very much.
Brilliant. Thank you very much. Take care. Thank you.
Goodbye.
Bye.
Absolutely waste of time. The legal ombudsman. They're a toothless waste of space organization, all right, that looking to act as in between. What you understand, these people have done criminality, they've committed fraud and deception, as a result of which I've suffered immensely, and all these people are going to do is add further delays, and we're going to investigate things, and I don't think this is true, and this is not my finding. This is one of the reasons that I too record this conversations and make it, and I think as a civilian, as a civil rights activist, as somebody, as a member of the public, I think the public needs to be educated and are made aware of exactly what we're dealing with when we're coming to these solicitors firms and solicitors and barristers. But more importantly, with the legal ombudsman, it's taken over a year, and we're still, toing and froing, and I'm not getting any satisfactory disclosure. Or these people are telling me, well, effectively they're staging the events that, trying to encourage me to not raise complaints, because they're saying you can either raise the complaints or alternatively withdraw them, and the matter can be proceeding a lot quicker. So effectively, I'm paying the price of raising additional complaints, when the reality is that this opportunity was denied to me from the onset, because I obviously wanted to raise more complaints, and the solicitors firm wanted nothing more to do with this after they got caught out for committing fraud and deception, and which resulted in my mother's murder. So this is the bottom line, is that they're just trying to refuse to effectively give me the answers that I need, or effectively do anything. They're just basically trying to run me around and infuriate me, and trying to get me to become antagonistic, saying, look, it's been so long, I've just forgotten about it. So this is just a delay tactic. So they will say that, as long as I give up on it, and I'm not expecting positive responses from the outcome of these people's investigation, considering the attitude and perspective that they've taken, that, oh well, we have to be impartial and respectful to the other people. That's fair enough, be impartial, but you have to demand certain things. All right, look, the client, the ultimate complaint is that you've not given us the case file. It's my case file. You've been the solicitors firm have been liaising and collaborating with the other party to my detriment. That is evidence that they cannot disclose to me, and by failing to make that disclosure, they're committing an act of fraud. Because or alternatively, if they do make that disclosure to me, then effectively they have given me evidence of the fraud, and they can't do that. They can't self-incriminate themselves. So that's what the problem with the solicitors firm. They're doing everything to not self-incriminate themselves, considering that they're doing something criminal, and so therefore they're avoiding to give me the case file. And ultimately, as you can see, that there's great failures on the part of the solicitors firm. It's just beyond belief what the solicitors firm have done. And obviously, ideally under these circumstances, the solicitors firm ordinarily, if I was paying them privately, they would have said, all right, look, we're not even going to charge you now, because obviously we don't want the money. But because they are collecting public money, the legal aid money, they have to collect it. They are therefore doing a criminal act. They know ideally this is the jig is up. We're gonna be caught now. But we can always say we didn't do it. We didn't have any financial gain. But because they got legal aid, they did get financial gain. All right, and so they can't come out with it. So it's far more serious when they are making financial gain through criminality, which is the case with the Burke Niazi solicitors. They're making financial gain through the collusion of the local authority, through using me as a legal aid mule in order to make money out of me, and then effectively getting me not to even be in a position to give them instructions, and trying to say that I lack litigation capacity. It was all one big contrived fraud. And now that I've brought it to the Ombudsman's attention, all they're looking to do is basically suspend the case, giving them more 8 weeks. You take your time all the time in the world. You can't avoid. My mum is not going to be undead. My mother can't be unmurdered now, and she's been murdered, and everybody's now running around like a headless chicken trying to find some resolution to a problem that they created. But yeah, I just wanted to ring up and finalize these issues with the Ombudsman, which is basically a waste of space, a waste of time. Ideally, the Ombudsman's there to ensure that public funds are not being misappropriated by malevolent organizations such as Burke Niazi solicitors. But effectively, they don't want to rock the boat. They're not interested in taking a solicitor's firm out, because obviously the solicitor's firm provide a utility to society and the system at large. So they would rather just basically have me screwed over like this and shut up. And I'm not gonna. But yeah, I just wanted to make that quick recording regarding speaking to the legal ombudsman regarding this ongoing contentious matter.